Well, good morning. This is Patrick Woodcock talking to you from the Maine Chamber's offices in Augusta. On behalf of the Chamber, it is my pleasure to welcome you to this webinar, Understanding Paid Family Medical Leave. We have two phenomenal contributors, panelists this morning who were in the trenches with the legislature in the design of one of the more significant labor laws in Maine state's history. I would like to begin by thanking our sponsors of today's event. Our presenting sponsors are Main Street Solutions and Verrill. Thank you. Our 2023 webinar series sponsors are AARP, Central Maine Power, Delta Dental, First Light, Kennebec Savings Bank, and Sun Life. Before we commence, here are a few administrative notes for today's webinar. I did want to let everyone know that the webinar is recorded for future viewing and will be made available on the Chamber's website and YouTube channel. We hope to have that available in the next day or so. Secondly, you've all joined this Zoom session with your microphones muted so we can reduce background noise. Third, if you become disconnected from the session, please reconnect using the same link. And we welcome your participation. Point of this is to have an engagement that elevates the questions that all of us have. If you do have a question for our panelists, please use the Zoom chat function at any time during the presentation. Please address your questions to everyone. If for some reason you wish to be anonymous with your questions, please send a private chat message to the Zoom host, Mark Ellis. We'll be happy to relay your question anonymously to the panel. We will address your questions as time permits. It is now my pleasure to introduce our panelists today. Tawny Alvarez is an attorney at Verrill who specializes in employment law, which along with many other issues includes wage hour, whistleblowing, unemployment compensation, workplace technology, and employment agreements. Secondly, Peter Gore is the Senior Government Relations Specialist at Main Street Solutions. For joining Main Street Solutions, Peter had a long career as the Executive Vice President for Advocacy and Government Relations here at the Chamber. During his 28-year career at the Chamber, Peter became known as an expert in the areas of workers' compensation, law, labor management issues, and healthcare and health insurance, as well as economic development. Welcome, Peter and Tawny. Again, I would thank you all for joining this morning. We have a significant attendance. We have a lot of outstanding questions as the regulatory process begins. Thank you very much, and I'll turn over to Tawny.
Thank you, Patrick. Peter and I are both really excited to be here today to talk about Maine's Paid Family and Medical Leave Act. We're sure that everyone has a lot of questions, and as Patrick mentioned earlier, please use the chat function and we will attempt to answer those questions as we are going through the presentation today. And with that, we'll get started, and I'll have Peter kind of go over the agenda and talk a little bit about all of the hard work that he did on behalf of the Chamber in Augusta during the course of the last few sessions.
Thank you, Tawny. I hope folks will bear with me today. I tested positive for COVID on Sunday, and so I'm day 3 into it. It's not the most fun I've had, but it's the second time around. So I'll do my best to maintain a cogent dialogue here. As Tawny indicated, the legislature took this issue up last session after having a commission meet for more than a year. I did see one of the attendees today as Representative Dick Bradstreet. He's a House member from Vassalboro, and he serves on the Labor and Housing Committee. So Dick went through the same thing that I do. I did represent the business community and was the lead business association lobbyist on behalf of the Maine State Chamber. They were my client last session. They will not be my client going forward. And there is a lot that is unclear about this law as we we'll begin to talk about it and you'll understand. I'm not going to spend a lot of time about the process. I will simply say this. What we have in front of us is a piece of legislation that ultimately started out as a standalone bill, but was placed in the budget document at the very end of the legislative session. After waiting 6 months for a bill to come out and being told it was the top priority, it ended up being the 1964th bill printed. And it came out at the very end of the legislative session. There was a public hearing and a single work session, and there were amendments presented at both the public hearing and in the work session that were not shared with the business community and did not have business community input. And at the end, this bill, this very sweeping workplace law was passed, and it is relatively incomplete in many areas. And it relies or will rely upon rulemaking that will take place starting this fall, certainly next year, and will require constant vigilance by the business community to make sure that in the time in the legislature where their concerns were not addressed, that perhaps in rulemaking some of those can be. So we're going to talk about definitions, eligibility, what the contributions and benefits look like, and then some other areas along the way. We do encourage your questions in the chat. We will answer them as we go. We won't wait till the end. There is a large crowd here. We have over 100 folks, and we're expecting more. So we will do the best we can to get through the pertinent information. With that, Tawny, I'm going to tag off to you.
Right. Thanks, Peter. As Peter mentioned, I mean, there's still a lot of things that are unknown here. During the course of today's presentation, we're going to speak both to what the language within the law itself provides, and then additionally, some concessions that were made kind of throughout the process, as well as language that currently is vague that we believe will be clarified during the rulemaking process, and what we believe those clarifications will provide and how that could affect the business community. Simultaneously, throughout the course of the presentation, we're going to weave in how this compares and contrasts with other obligations that employers currently have that relate to paid forms of leave or unpaid leave forms, including Maine's current Family and Medical Leave Act, which is unpaid, and the federal Family and Medical Leave Act, which would apply to not everyone who is joining us on today's webinar, but a vast majority of people likely fall under either the Maine Family Medical Leave or the federal Family and Medical Leave if there's over 15 employees for the state statute and over 50 for the federal statute. So you're going to hear us reference those. If you don't have over 50 employees, then you don't have to worry about the federal requirements that we'll kind of weave in here. And if you don't have over 15 employees, no need to listen to kind of our dialogue concerning the state benefits. But it is important that you understand how this law is going to interact with other obligations that employers currently have and rights that employees currently have. So with that, let's jump into an overview of the law, Peter, as it currently stands.
So I think there are some important differences. As Tawny indicated, there is a state and a federal FMLA law that has long been in place. It is unpaid. In either of those cases, it affects employers with more than 15 employees. What needs to be clear is 1964, or the Paid Family Medical Leave law, will affect all employers regardless of size. And that also sweeps in sole proprietors and independent contractors as well. It impacts all Maine employees, including full-time, part-time, seasonal workers, and as I indicated, sole props and independent contractors and student workers. The benefits are funded through a payroll tax, which is estimated to be roughly $360 million, and also includes $25 million in startup funding for the Department of Labor to begin the process of implementing the law. This is why it was ultimately put in the budget. If you're an employer with more than 15 employees, the employee will pay for 50% of the cost, and the employer will pay for the remaining 50% of the cost. So more than 15 employees, it's a 1% payroll tax. You, the employer, pay 0.5%. The employees pay the other 0.5%. If you have fewer than 15 employees, the employer appears not to be required to make any financial contribution, but the employees must provide 50% or 0.5%, that 1% of premium, and the employer then would refer it on to the state. The only eligibility requirement, and there's been a lot of talk about number of days that someone needs to work for the employer, et cetera, et cetera. There's really only one eligibility requirement, and that is that the employee earns 6 times the state's average weekly wage over the previous 4 quarters. That's roughly about $6,600 in a year. Tawny, you want to add anything to any of that?
Yeah, a couple of things. We're not working from an absolute clean slate. We're not the first state in the United States to kind of create a paid leave program. Not exactly what Maine has done. There are differences between other states and what we're seeing here, but we've seen other companies who have or are operating in states that have a paid family medical leave program such as this, who've taken this program and looked at it as a way to kind of increase benefits to employees and say, listen, everyone is going to have to pay this tax of the 1%. Or 50% of the cost to the employer, or 50% to the employee. But what we're going to do as an employer, a lot of large employers will do is say, never mind, you don't have to cover any of it. We're going to cover 100% of the cost. So while right now we know that employers that have 15 or more employees are able to transition and force employees to pay 50% of that 1%, there's a chance that employers could permissibly pay the whole amount of this tax. And we do see that possibility in other states. So one of the things with rulemaking that we're going to be looking for is, are you required to pass on all the costs? Could an employer take all the costs on if they want to? Additionally, kind of when we look at 6 times the state's average weekly wage, we're looking at that over the last year. So as long as someone has made $6,622 in the prior year, as Peter mentioned, they immediately are going to be eligible. So on day 1 at a new employer, they would be able to apply for paid family medical leave. So that's really important to understand, because I think previously there's been some disinformation that this only applies to larger employers or only applies if you have 15 or more employees, and that's just incorrect. So understanding that is really important. We're going to go through some more about kind of how the pay would work out and what percentage of benefits individuals will get, and we'll move through that as we go through the presentation. So let's go to that next slide, Peter.
So one other thing, Tawny, I was going to touch on the payment of benefits, or the payment of the tax. While the way it's currently structured, with smaller businesses not being required to pay into the fund, only their employees, you do have a situation where anyone who's on this webinar and is a larger employer, in many ways, you'll be subsidizing the small employee market with your premium. So I just want to be clear about that. So an employee is entitled to paid family medical leave and to job protection if they have been employed by the employer for at least 120 days. But that does not mean they cannot access leave prior to the 120 days. In fact, you can. You could actually take leave after being with a business for 2 weeks, but you're not necessarily entitled to the job protections. Well, you're not entitled to the job protections that are found in the law. However, as an employer, if someone works for you for 2 weeks and then invokes their right to take paid family medical leave, and you decide that you want to permanently replace that worker, that's within your rights. However, you will continue to pay all the benefits for that worker who's out for the remainder of the 12 weeks. So you will double pay benefits. You will pay for the new replacement worker and the existing benefits for the worker that took paid family medical leave. Private plans are authorized under the law. They have to be substantially equivalent to the requirements of the state-based plan. This will be determined through rulemaking that the Department of Labor will undertake to define what substantially equivalent is. One, however, needs to assume that it pretty much would look like everything that's found in Maine's paid family medical leave law. An employer cannot deny the use of the leave under this provision. They have to retain the position, as I indicated, and continue to pay benefits, and as I said, pay benefits to the replacement worker as well. Employees who are found to have engaged in fraud or misuse, which would include the collection of benefits obtained under false pretenses, would be barred from receiving additional benefits for a period of 1 year. There is no requirement that those fraudulently obtained benefits would need to be repaid, and it's only a 1 year essentially phase in which you could not reapply for leave. Our law has the most generous paid family medical leave benefits in New England, and we will be the only northern New England state to require employers to contribute through taxes to the entire program. Connecticut, Rhode Island, New Hampshire, Vermont, and Massachusetts do not tax employers to pay for these benefits. Massachusetts pays for taxes for medical benefits, but not family leave benefits. So we are the only state that is currently taxing employers to pay for the fund. Tawny, you want to jump in?
Yeah, so as it relates to some of the things that Peter's just mentioned, you know, I think that a lot of individuals and organizations are saying we already offer short-term disability leave, and our short-term disability leave is for over 12 weeks, it's for 16 weeks, or it's for 26 weeks, and accordingly aren't paying attention to kind of the institution of this new law. The thing is it's highly, highly unlikely that your short-term disability policy is currently substantially equivalent to the requirements of the new state-based program. And that's in large part because of some of the definitions that Peter and I are going to talk about in more detail in the next slide, specifically the definition of what a family member is. As well as the definition of different health conditions that can be covered underneath the statute. So that's the first thing is, you know, this is larger than just your short-term disability policy because it includes that family medical leave aspect of it as well. Additionally, you know, you'll recall that we mentioned earlier that employees are entitled to this on their first day of employment, as long as in the last year they made $6,622 in the prior year. And that number is going to evolve. As the minimum wage evolves, that number is going to continue to grow. But if right now the Paid Family Medical Leave Act was implemented in 2024, that would be the number that we are looking at. Also kind of important to understand that even though there is the ability to for the state to take away, I don't want to say take away, but withhold benefits in the future if there is a determination or fraud or misuse, we currently don't have any way in which it's clear how employers and the state or the department are going to communicate with each other concerning leave. There are very strict confidentiality language within the statute right now, indicating that the department will not be sharing information with employers or third parties So how employers are going to communicate if they believe fraud or misuse is occurring is going to be a very interesting process that is further going to be developed during rulemaking. And with that, let's turn to definitions, Peter.
So the application year is the 12-month period beginning on the first day of the calendar year in which an individual files an application for family leave benefits or medical leave benefits. So in other words, if you file an application to access benefits in any 12-month period, it's confined to the 12-month period. Why is that important? Because as originally drafted, it was a rolling calendar. So it set up a situation in which if you filed for benefits in the last quarter of the year, you could immediately refile for benefits in the next calendar year and end up taking 24 weeks of benefits rather than 12 weeks. So this change was made during the committee process. As Tawny indicated, the definition of family member under our law is very broad. It includes children, parents, spouse, grandparents, grandchildren, and then de facto family members, de facto children, de facto parent, de facto grandparent or grandchild. It's not really clear what that means. And then it adds a different element on top of that, and that's an affinity relationship. And you can see in the definition on your screen, it's a relationship is shown by the covered individual, any other individual with whom the covered individual has a significant personal bond that is or is like a family relationship, regardless of biological or legal relationship. So in a sense, what we argued in the committee process was you could be talking about your roommate that you share rent with, that perhaps you're tight with. And there were no guardrails set around this affinity relationship definition. What's going to end up happening is, as we were told during the committee process, that rulemaking would narrow an affinity relationship to one person that the individual would name. So you couldn't change that year after year, time after time. And that's what California has done. But again, I want to go back to the importance of the rulemaking process, and items like this and how this shakes out will be very important from a management perspective by employers. Tawny?
One of the other things that isn't touched upon at all in the course of this statute is how employers are going to respond if they employ both family members. So whether or not you have two spouses who are employed, whether or not you have the family relationship itself. So under federal FMLA and state FMLA, there's guidance concerning the use of family medical leave eligibility, especially for the birth or care of a child or an adopted or foster placement kind of situation. In the current scenario in the law, you know, we don't have any guidance. We expect to have a better sense during the rulemaking process about what that will look like if you have multiple family members employed by the same employer who are dealing with or who are going to be providing care either to another family member or to a covered individual. So important to understand kind of some of those definitions. Also really helpful, you know, I want to be at least a little positive that the application year language did evolve. I mean, in the first iteration of the bill, the application year, like Peter said, you know, somebody could have taken significantly more than 12 weeks of leave. If they took leave in the last quarter of the year, they could have stacked that leave. So by having that rolling calendar year, it's helpful for employers as they attempt to navigate leaves during the course of this period. Falling hand in hand with definitions, however, is eligibility. So let's jump through that a little bit. And eligibility is very similar to the eligibility that's provided under state FMLA and federal FMLA, but it actually is even broader. So we do have language that an individual can take leave to bond with their child during the first 12 months of birth or placement for adoption or foster care. And recall that child is broad, okay, in what the definition of child is, going back to that last screen, meaning not only parentage, biological, adopted, foster, stepchild, in loco parentis. So a very broad definition of child under the statute at this time. To care for a family member with a serious health condition. And a serious health condition, the definition is different from what we see under federal law. Under federal law, there's language that says, that results in incapacitation for 3 or more days. That language is not in this definition. Instead, what we're seeing for a health condition under the law is something that requires inpatient care or ongoing medical treatment. One of the questions that we received already was, how does one qualify for intermittent leave with a 7-day waiting period in place? And to kind of the question itself gives another requirement, and the requirement is, in order to be eligible, you have to wait 7 days and then you'll be eligible for that base period. It's a really good question, because right now we don't know whether or not the intermittent 7-day period is just 7 days out of work that could span over a period of time, if it's 7 consecutive days that are required. And why this becomes even more important is, if you look here on the screen, section E, to take safe leave, that would require, so safe leave is similar to Maine's current domestic violence leave statute, which provides leave in order to care for either legal proceedings, health care, mental health care concerning some type of violence or that's been directed to a family member or to the covered individual themselves. So this safe leave's provided, but right now we don't know if that would be, okay, do you have to take 7 days over the span of 1 week, take 1 whole week off? Or if you're an ongoing victim of domestic violence, or if you have a family member who's an ongoing victim of domestic violence, can that be taken in an intermittent basis? And after 7 intermittent days, you could then apply. We have the qualifying exigency language. We have the covered service member language. Those are both similar to what we see under state and federal Family Medical Leave Act. We then have this catch-all language, any other reason that's set forth in section 843, which is Maine's current FMLA statute. The additional language that wasn't included in the statute, but it is included in the in the state law, would be organ donation. It is another eligibility form. And then death of a service member is something that isn't currently covered within the paid family medical leave, but is one of the reasons set forth in subsection 4 of the current FMLA standard. So that's kind of generally some of the key points about eligibility. Peter, something that I'm missing, or we should go into more detail on, you think?
No, but we did have a question from our audience, and it is, will there be a mechanism for employers to challenge questionable claims of affinity relationships without creating undue risk for the company? And the answer, I think, that I would give you at the moment is, we don't know. But following that up, as I indicated, what constitutes an affinity relationship will be determined through rulemaking. They are intending to narrow it down, so an individual in your company could only choose one person as an affinity relationship and not 10. But again, we haven't seen what that proposed language will look like. I had a conversation with Laura Fortman, who's the Commissioner of Labor, earlier this summer. They're not even thinking about rulemaking at the present time until the law actually kicks in, and that's at the end of October. So I think at the end of this month, you'll start to see the department do some things around rulemaking, but a lot of that's going to take place next year.
And that is a really good segment, Peter, to our next slide, which is about the timeline of everything. Why don't you tell a little bit about kind of the timeline that we're currently looking at here?
So currently, as you can see from the slide, employers would be required to collect from their employees and pay if they have more than 15 employees beginning January 1st, 2025. And after a year of collections and assumably capitalizing the fund, benefits would begin theoretically in January of 2026, but there's a sort of a circuit breaker there that they could be postponed if they feel not enough money has been collected for the fund, and they wouldn't actually start accepting claims until May 1st of 2026.
So one of the kind of questions that I think a lot of people are asking is how much money do people receive? Are they receiving their whole entire paycheck? Is it full wage replacement, or is it some lower amount? For an individual who makes minimum wage, they would receive 90 and works full-time, so 40 hours a week at minimum wage. They'd receive 90% of their pay, or $496.77 a week. So this is based off of our current numbers. If the statute went into effect today, that's the numbers that we would be looking at. For someone who makes approximately $100,000 a year, they would receive 57% approximately of their pay. And for somebody who makes approximately $50,000 a year, they'd be looking at a take home of about 80% of their wages. And that's based off of kind of the formulas that have been set forth if we were to use current data using that formula. So that is just a little bit of understanding as to kind of what benefits will employees be receiving. Now, for a lot of people, that is more, if we just look at short-term disability plans, many of them are wage replacement at 66% only for the covered individual's own health condition. So remember, this is broader than most short-term disability plans, right? And it also is providing wages at a higher rate. If you're making minimum wage, it's at 90%, $50,000 a year, 80%. Most of the plans that I see or work with are at 66% approximately. So be mindful of that. You know, one of the questions that we just received is, will this take over our current short-term disability plan? I think it's definitely something that as you're working with your finance team and trying to figure out how you're going to move forward into 2025 and 2026. Remember, 2025 is when we're going to begin making contributions, whether or not your short-term disability policy, if you want it to expire in 2026, because it likely will not be providing the benefit that is necessary under the terms of this act, and simultaneously would not qualify as a plan that is parallel in benefits as required under the statute. And we'll talk a little bit more about kind of what that would look like. But I think even once we see rulemaking, it's highly unlikely that many employers' current short-term disability plans are going to be sufficient, because it's not going to include up to the rate that is provided underneath the statute. Peter, more to add there? Okay.
Yeah, I was just, the language in the law is pretty simple. If you make more than 50% of the state average weekly wage, your benefit replacement amount is 66%. If you make less than 50% of the state's average weekly wage, your benefit replacement is 90%. Those are the highest benefit replacement rates in New England. And I have had conversations with larger employers who provide a more generous short-term or long-term disability plans, and they're concerned because while their low wage earners or lower wage earners do well in this, and by the way, there was a last-minute change to make this fully taxable, for a long time, none of these benefits were taxable at all. But so if you're a lower wage earner, you do pretty well. But for the high wage earners in your company, the plan that the state has makes them essentially losers in this. And you may have to figure out whether you need to do a bootstrap policy for your higher wage earners to make them whole through this process. Otherwise, you're going to have some unhappy employees on your hands.
Jumping kind of to the amount of leave. So we've talked about how much money, but how much time. So the following requirements apply. So a covered individual isn't eligible for more than 12 weeks of family leave in an application period. They are not eligible for medical leave of more than 12 weeks in an application year. And a covered individual cannot take more than 12 weeks in the aggregate. So together of family leave and medical leave under the subsection in the same application year. And recall, application year is that rolling time frame from the first date of leave. There is language in the statute, however, that provides that this doesn't prevent a covered individual from taking medical leave that's immediately followed by family leave when the medical leave is taken during pregnancy or recovery from childbirth and is supported by documentation from a healthcare provider. This sentence is something that I'm very interested to see the rulemaking on, to see how this is interpreted. I mean, from a legal perspective, the courts always say that the legislature doesn't include superfluous language in a statute that's unnecessary. So understanding kind of exactly what they mean when they say this, do they mean that somebody could take 24 weeks? Or do they mean what's set forth in subsection C, that you're only allowed 12 weeks, will be a question that I think a lot of employers should have at top of mind, especially when we start going through the rulemaking process. Peter, other aspects of this language that you think it's important to point out?
No, I think you've hit them.
I'll turn it over to you, however, Peter, to talk about some of those benefits that are available to employees during their leave.
As we touched on earlier, when an employee holds their right under the act to take the leave, it cannot affect their right to accrue vacation time, sick time, bonuses, advancement, seniority, and I want to include in here earned paid leave, because although it doesn't say so, earned paid leave would be included. And the employer, for the duration of the leave, is required to pay for those benefits and health insurance benefits in particular. As we indicated earlier, if you make the decision to replace somebody permanently, in other words, they haven't been there for 120 days, you are still on the hook to pay for that replaced worker's benefits for the 12 weeks that that individual is accessing their leave. And furthermore, if you permanently replace that worker, it was never made clear, despite our concerns, that if that replaced worker then files for unemployment insurance, that you're not on the hook, or at least your experience rating is not on the hook to pay for that unemployment insurance. It was not made clear, despite our efforts to get it so, and that's a concern. Tawny?
One of the questions that we've gotten a couple times now is that what's the maximum weekly benefit? And we don't have that answer. I mean, it's going to be defined by rulemaking. I presume that it will evolve each calendar year, that we'll see a new maximum weekly benefit as to what the high amount is. It likely will depend upon the fund itself and the money that's within the fund in determining some of those things, but that currently is an unknown. There are a couple of things that if you are in HR that you need to be really mindful of as it relates to benefits during this leave. Some employers have their payroll and their current paid leave set up in such a way that individuals only earn whether it's vacation time, whether it's earned paid leave, whatever the benefit is based off of hours actually worked, so that individuals don't earn vacation on vacation time taken. So if you take 8 hours of vacation, you don't earn an additional 0.2 hours of vacation leave. If you're currently set up that way, you're going to have to change your policy so that even the time that an individual is not working, they are earning benefits. That's specifically, as it stands right now within the statute, what it would appear the legislative intent was, so that individuals continue to accrue vacation time, sick time, bonuses, advancements, seniority, length of service credit. All of that kind of would have to evolve. Additionally, for employers who pay using a commission structure or using some other type of bonus, if you have language in there that requires that the employee be actively employed or providing services for X, Y, and Z period during that time in which the commission is based off of, you're going to have to be mindful that you may need to evolve those policies based off of these rules or the current legislative language. Another aspect of this that is really important to keep at top of mind is there's a specific provision that provides that an employer cannot compel an employee to exhaust rights to any sick, vacation, or personal time prior to or while taking leave. So I know that a lot of employers' current policies, if you are above 15 employees or above 50 employees, you might say, yes, of course, you're entitled to Maine family medical leave, or you're entitled to federal family medical leave, and you're entitled to that 12 weeks of unpaid leave, but you simultaneously have to first use all of your paid vacation or paid sick time kind of before you then use Maine or federal Family Medical Leave Act. A policy or requirement such as that would not be permissible under the current statute. So you cannot compel an employee to take that leave. So if you're an employer who already offers very generous leave benefits, so you offer 4 weeks of paid leave, you need to be mindful that employees are going to be entitled to take their 12 weeks of paid family medical leave and then their additional, 4 weeks of vacation or PTO. So just keep that at top of mind kind of as we move through this process and the rulemaking continues to develop. Peter, anything else concerning benefits, or should we jump to how this program is going to be funded?
We'll jump to the funding. So we already talked about this at the beginning, but beginning in January of 2025, that the employers are required to remit the funding premiums but to the administrator of the program. It's important to point out that there is some ongoing pushing and shoving around who the administrator of this will be. Many of the proponents of this proposal wanted this to be the state, and in particular, a new bureau within the Department of Labor. Other folks did not want it to be administered by the state and would prefer to have it contracted out through a different entity or agency or business. And there are many that do this turnkey in other states. There is a provision in the law that allows the state to accept RFPs to run the program. How that proceeds is not clear yet, or when it will happen. For now, the Department of Labor will be hiring an administrator to run the program before the end of the year. Beginning January 1st, the premium amount is, as I indicated, 1% of wages. So in other words, 1% of your payroll, if you have more than 15 employees, that's what you'll be paying in total for your workers and your business. Like the next bullet says, if you have more than 15, you pay both. If you have less, then the only contribution is the employee's contribution. I see problems with this going forward. And in addition, and I've had conversations with folks, at least one of whom is on this call. I just saw Jeff come in. What's going to happen if we don't have a clear indication of what constitutes a substantially equivalent definition? In other words, if there are larger employers out there who wish to contract or purchase a private plan that gives them greater control over the use and when and how the leave is going to be accessed, if that's not clear by the January 1st of 2025, then what do larger employers do? Because they could start paying in and then at the same time, once it is clear, opt out and purchase a private plan. But then they've paid twice. It's yet another problem, and we'll have to see how some of this is worked out through rulemaking. Tawny?
I don't have anything to add as to the funding aspect. There is language in there that indicates that at some point in the future, it could be more than 1% of wages. So that is in the statute. So we could see an evolution based off of the fund itself and how it's managed. But at this point, it's 1% with the understanding that there is language within the statute that could grow to be more than 1%.
The authority has the option to increase by, I believe, 0.1% each year without any kind of oversight from the legislature. They just have that authority to maintain fund balance and fiscal responsibility.
Absolutely. Let's talk a little bit about pay during leave. So what will the employees themselves be receiving? We talked about this briefly, but the big thing is right now we don't know. You'll see on this slide 66% of the maximum weekly benefit. We don't know what the maximum weekly benefit is or will be. So that's something that rulemaking, we're going to have to wait for, with the understanding that individuals who make minimum wage, they'll see 90% of their pay through this program. And if it were to take effect now, that would be approximately $496 a week. But it's going to be calculated again based off of the past 4 quarters. So if an individual was unemployed for some period of those 4 quarters, we would be looking at less than those numbers that I have just quoted. Peter, anything here? Do you want to jump to that second part of pay?
No.
Okay, so we're gonna jump to the maximum benefit amount adjustment. So that's 100%, 120% of the state average weekly wage. And then claims begin to be processed by October of 2026. And January 1st of the year in which the claim begin being processed and annually thereafter. One of the things that's important to understand is the application process itself. An individual can file an application for family leave benefits or medical leave benefits up to 60 days before the anticipated start date of the family or medical leave, but they also could file it up to 90 days after the start of family leave or medical leave. For my HR team members who are in the room, this is going to create a pretty big headache, I think, for a lot of employers, because we potentially have employees who could not apply for the benefit, who could be out of work for, I won't say 90 days, but for multiple days without even having applied for this benefit. And recall, you can't take adverse action against somebody as a result of applying for this benefit. Have they applied for it? Are they eligible? Employers don't determine eligibility. The state's going to determine eligibility. So I think for some of our employees who may have either performance or behavioral concerns that are already in place at a time in which they then seek to take protected leave, there's going to be a very fine line between how we move forward in making sure that we are not adversely affecting employees' protected rights under the statute, but also operating appropriately and holding all individuals to the same standards. Peter, anything additional to add kind of to this pay during leave?
I do not.
Okay. And I've kind of like paved the way into it, but Peter, let's talk a little bit about retaliation kind of generally and what happened up in Augusta at the end of the session.
Well, as the committee rushed towards putting this bill out, there was some discussion around a hardship exemption. And basically, you can see here, if it would impose an undue hardship on the employer that results in significant difficulty or expenses to the employer, or considered size, et cetera, et cetera. There is a section in this law that proponents indicate is a hardship exemption for businesses. If you look at the language, and we looked at it, and Tawny, I think this is what you and I were talking about earlier, it doesn't really say 15 or less than 15 employees. It basically appears to apply to all employers regardless of size. But all it says is, they have to schedule the leave at a time in which it doesn't present an undue hardship on the employer. It doesn't say that the employee can't access the leave, and it's not clear if the employee says, look, I can't wait to take the leave, I need to access it now, regardless of whether it puts an undue hardship on you or not, and they leave and they take the leave. What is the employer to do in that situation? Or the employer says no, or they discharge them. It's a very loose set of what would constitute a hardship exemption language. It's not going to be clear to businesses. It's certainly not going to be clear to small businesses. I think that, when Tawny and I talked earlier, we said it's unlikely a larger employer is ever going to use a hardship exemption. They're not going to be granted it because they have enough workers. So if someone goes out, they could be replaced. The idea is it really is a small business exemption. But I just don't think it has any teeth in it for the small business community. Tawny, I welcome your thoughts.
Yeah, no, Peter, thank you for all of that. So, if you're sitting there with a copy of the statute in front of you right now, you're likely saying to yourself, Tawny, it doesn't say anywhere, that the hardship exemption applies for 15 or fewer employees. But this goes back to that caveat we made at the beginning of the presentation, is recall that paid family medical leave does not live in a vacuum, okay? If you currently employ 15 or more employees under Maine's Family Medical Leave Act, the unpaid provision, right? You must provide up to 10 weeks of unpaid leave over a 2-year period to employees. There's no hardship language there. You must do that. Just like if you have 50 or more employees under the federal law, you must provide employees with 12 weeks of leave in any 1-year period. And you can define that 1-year period however you wish. So paid family medical leave doesn't live in a vacuum. So when we talk about hardship exemptions, yes, maybe the language itself says, if it imposes an undue hardship, you may have these other abilities to take action against an individual, but that's only under the statute. You wouldn't be able to do that under federal law. You wouldn't be able to do that under state law. And recall, you're going to continue to have those obligations. So as it currently stands right now, the Maine Family Medical Leave Act will still be around. You will still have obligations under that. Employees will still have private rights of action if you fail to comply with the obligations under that statute or under the Federal Family and Medical Leave Act. So just be very mindful that, this does not live in a vacuum. You continue to have obligations under these other statutes. Going to some of the questions that we're getting based off of the last couple of slides, a question, essentially, an individual could voluntarily be terminated as a result of job abandonment because they didn't communicate with their employer. And then up to 90 days later, we could hear that they actually wanted to apply for paid family medical leave and retain the job. based off of the current statute, yes, it's our hope and goal that under the rulemaking process, we'll get a better sense as to what employers' obligations are if they have no understanding that the employee is attempting to apply for leave, if they haven't communicated a serious health condition. Currently, we see employers who deal with this a lot, specifically when we look at employees who have gone into some type of recovery program where they might not have access to or be able to communicate with the employee. So we'll see some of the tools that employers have implemented around that that's going to come into effect kind of during this process. So right now, the language is you have up to 90 days after the leave has already started to make the application, but how employers will understand what to do in that period of time remains unknown.
Hey,
Peter?
Tawny?
Yep.
Yeah, I want to go back. There's two more questions. It says, unclear if employers can challenge the claim or need for leave. What mechanism will exist for employers to receive information timely? That is a very important question, and it's something that we argued, those of us who represented the business community, and I just want to give a shout out to both Nate Cloutier with Hospitality Maine and Jeff Austin with the Maine Hospital Association, who are part of our group, and they're both on here today, who worked on this issue. The fact of the matter is the law contains there's no mechanism for employers to challenge the need for the leave. And part of the concerns that we echoed to the committee and to the governor's office and the proponents were the way this is structured right now, and perhaps rulemaking will take care of it, but perhaps it won't. The first time an employer learns that the employee has told their rights and is out on leave is when they don't show up for work. That's the way it's structured right now. I really want to be clear about that. And the second question that's come along is how is an employer to handle multiple employees at a time applying for this benefit? With the eligibility being so broad, it's very realistic to expect several businesses, several people out at the same time. Exactly. That is exactly part of the problem. And there is no mechanism and there is nothing in the law to assist employers with absenteeism. Part of what we talked about, again, in the legislature was employers can't find people for full-time work today. They're not going to be able to find replacement workers for someone to come in for just 12 weeks and fill in for these folks that are out on paid family medical leave. So what are they to do in this situation? I think that the idea was that this hardship exemption would play a role in that. But again, if you read the language, and if you read the language in the law, it simply says that they have to schedule it, but there's nothing that says to the worker or to the employer that they can say, no, you can't take the paid family medical leave right now, and if you do, I'm within my rights to fire you. There's nothing in that hardship exemption that does that. Not that you'd want to. I'm not saying that you'd want to. Most employers are never going to treat their employees that way. But in terms of questioning what you do for multiple absences at the same time, there is no good answers for employers in this law.
And with that, I mean, Peter, you did a nice job. We have a couple of slides that kind of compare where we ended up finding ourselves and then what the task force had recommended, and then also what the Maine People's Alliance initiative was more generally. We are just about out of time, so I'll let you, Peter, if you want to run through in the last minute this, and then I'll turn it back over to Patrick.
I don't have a lot to say on this, except I do. This is Jeff Austin's slide that he put together while we were working on this. I think it's very important to recognize that the presence of the Maine People's Alliance's ballot initiative played a huge role in how this shook out in the legislature. So from a multi-systemic standpoint, politically, you had the Maine People's Alliance initiative out there, you had the commission's recommendation, and then you had the sponsor's bill in and of itself. Part of the argument the business community made that was that the Maine People's Alliance proposal should be the ceiling for anything that the state enacts, and we should look for something less that's more manageable and reasonable and aligned with the rest of New England. And we didn't get that. what we got was the Maine People's Alliance proposal ended up being the floor, and we ended up enacting a more generous proposal than even they had in mind. So with that, I mean, we've had some questions. We are about out of time. Patrick, I guess I turn it back over to you.
That was extremely informative. I want to thank Tawny and Peter, especially for persevering through an illness, speedy recovery. A few takeaways: the timing of this and the amount of discretion through rulemaking is staggering. I will just offer that the chamber is going to be taking an active role in collecting a position on key issues that we'll be providing. We've already spoken with Commissioner Fortman about the topic, and it's really going to start off, as I think Peter noted, when the law takes effect at the end of this month. I did want to say thank you again to our sponsors. This wouldn't be possible without them. Thank you to Main Street Solutions and Verrill, as well as the presenting sponsors that you can see on the slide below. Thank you very much for participating today, for the questions. This will be the first of many engagements on this topic. Thank you, Tawny. Thank you, Peter, and have a great day.